Okay, so I'm going to do this a little differently. I'm going to basically go over mostly just the correct answers so that you're only hearing the correct answers. But in some of the questions where it's like long lists, I'm going to explain why some of them are incorrect. So the family court has exclusive original jurisdiction over what? And if you can just memorize the articles, it's 3, 4, 5, 6, 7, and 10. Okay? So again, exclusive original jurisdiction, 3, 4, 5, 6, 7, and 10. The reason Article 5 has a star next to it and Article 6 has a star next to it is because proceedings to terminate parental rights, which is in Article 6, there's certain circumstances when, depending on what it's based on, the surrogate's court can do it. But if it says proceeding to terminate parental rights based on permanent neglect or both parents dead, no guardian lawfully appointed, all of those are going to fall under this. Most likely, if they give you this question, Article 6 is going to be included in there as something that has exclusive original jurisdiction. Now, Article 5, the key words that you have to look for to make this right, now it's wrong because it's incomplete here. It says proceedings to determine paternity. That's not enough because certain times surrogate's court can establish paternity, okay? But if it's paternity for and support for children born out of wedlock, you're good. Article 5 is included. So when is it always? It's always 3, 4, 7, and 10. Okay? Always 3, 4, 7, and 10. Mandatory. Gotta go to family court. Most, like 99% of the time, Articles 5 and 6, you're also going to family court, exclusive original jurisdiction. You're going to get this question right. I could just feel it because you're going to read this over and over again, and you're just going to remember 3, 4, 5, 6, 7, and 10 for exclusive original jurisdiction. 2, a family court judge may administer oaths and take acknowledgments, issue a subpoena ducis tecum, order a warrant, hear and decide motions relating to child support subpoenas, and issue a temporary or final order of protection, which is not a choice here, but just so that you know the difference between what a support magistrate can do and what a family court judge can do. Now, a support magistrate, there's a couple things they cannot do. 1 is a warrant. 2 is an order of protection. 3 is finding someone in summary contempt. A family court warrant of arrest may be executed at any time of the day or night and anywhere in New York State. So if there's a family court warrant issued in Saratoga County and that person is picked up down in Queens on something else, they can execute that family court warrant also. Which are true when a person appears at family court and requests a TOP. So I come to the family court counter. It's 4:59 p.m. on Friday afternoon. I say I want to file a petition. Guess what? You got to let me file it. At 4:59, 5 o'clock on Friday, I got to file a petition on the same day. And I get a hearing either that day or next day family court's in session, which is probably going to be Monday. So when a person arrives at family court and requests a TOP, such person is entitled to file a petition without delay on the same day he appears, and a hearing has to be held either that day or the next day family court is open. If the court orders that a respondent or petitioner's address is to remain confidential, papers directed to that person may be served on either the clerk or a disinterested person designated by the court, and that's it. Only those 2 things. Next, this is a material witness 1442 rule. So when a child under the age of 16, so that's 0 to 15, is placed in protective custody as a material witness pursuant to family court order, said order may extend for a period of no more than 14 days, but they can get 2 extensions of more 14-day periods, but the total time cannot exceed 42 days. Question 7 is a question that is literally on every exam, so you have to know this one cold. I'm going to try to give you a good way to remember this. So it's other than Article 4, so other than a support proceeding, a respondent pretty much is going to get free counsel if they're indigent. So again, all the articles except for Article 4, the respondent is going to get the free attorney. So what do you exactly have to memorize? Well, you have to memorize when the petitioner gets it. And if you just remember, they're 8s. Remember, somebody's living in Section 8 and they're a petitioner in Article 8. They get a free attorney. If it's Part 8 of Article 10, petitioner gets a free attorney. So when does the petitioner get a free attorney? Article 8 and then Part 8 of Article 10. And the reason that is because Article 10, as you know, is abuse and neglect. The kid gets taken away, put in foster care. Part 8 is a petition to visit your kid that's in foster care. So it stands to reason that you file that petition under Article 10, you already got a free lawyer because you were the respondent in the original petition. Now you're making a petition to visit your kid in foster care. You're still going to keep your lawyer, even though you're technically the petitioner. The other caveat I'm going to give you about Article 5 is that it's only to establish paternity. Once paternity is established, you're not getting a lawyer anymore. You're not getting the free lawyer anymore. So, and that makes sense because in Article 4 you don't get it, even if you're the respondent, you don't get it. So why would you get it to argue about child support? You get it for the purpose of establishing paternity, and then that's it.